Welcome to Corporate Law and Governance. My name is Tara Tešić, and in today's episode, we examine the case of L'Oréal SA and child labor in Jasmine Supply Chain, French fiduciary duties, duty of vigilance, and board oversight. Over the past 2 years, a series of investigations, most prominently the BBC documentary Perfume's Dark Secret, documented children working through the night to harvest jasmine in Egypt's Garbia region. These flowers, picked before the dawn when their fragrance is the strongest, move from small family farms to local processors, then to international fragrance houses, and ultimately become key components in perfumes sold worldwide, including L'Oréal. The reporting revealed long-standing structural challenges in the jasmine sector: low farm gate prices, economic pressure on families, and reliance on informal labor systems that often involve children. Major brands still benefit from this chain, raising concerns about transparency and accountability in global sourcing networks. After the investigation aired, several companies issued public statements, and the jasmine industry reserved heightened scrutiny from NGOs and journalists. L'Oréal acknowledged the seriousness of the findings and joined initiatives aimed at improving conditions in the region. These developments have highlighted not only the factual circumstances of jasmine production, but also how multinational companies supervise complex supply chains. In today's program, we present a structured analysis of the case. Our discussion begins with the overview of the L'Oréal's general vigilance approach, followed by potential civil implications, potential criminal implications, and finally, a judicial perspective. Each expert will present their segments independently to keep our discussion focused and clear. To begin, I'd like to introduce Sigan Lu, our foreign correspondent from Egypt, a specialist in corporate supply chain monitoring in Egypt, who will outline L'Oréal's general vigilance approach in connection with the factual background we've just covered. Sigan?
Let me bring the discussion closer to the legal framework by outlining what L'Oréal's vigilance system was actually required to do in a supply chain like the jasmine sector. Under the French duty of vigilance, the vigilance plan is not a PR tool, it is the statutory mechanism meant to prevent exactly the type of human rights risk at the issue here. For a company of L'Oréal size, the law actually requires 5 elements: a mapping of cyber risk, an assessment of the subsidiaries and key partners, appropriate preventive measures, and an alert mechanism and a system for monitoring how effective those measures are. So the real question is not whether a plan existed, but whether it was sufficiently tailored to a well-known high-risk environment such as the Egyptian jasmine. The risk of child labor in this sector is neither abstract or new. NGOs and journalists have documented persistent vulnerability for over a decade, and the legally adequate vigilance plan should therefore identify this as a foreseeable risk, prioritize it in the risk map, and also design proportionate preventive measures. Based on the information available, L'Oréal's plan does mention human rights risk and join the industry initiative. But from a vigilance law perspective, the issue is whether its measures were concrete enough and whether monitoring could detect ongoing violations in real time. Recent case law, such as La Poste, shows that the courts now look beyond formal statement and ask, is the risk map too generic? Are preventive actions adapted to conditions on the ground? Does the company gather the reliable information from deeper tiers of the chain? These are the questions a court would examine, and this sets a legal context for our next speakers.
Thank you, Sigan. Our next correspondent is Vita Capuzziello, an attorney experienced in civil matters involving multinational enterprises. She will discuss the potential civil implications arising from these circumstances. Vita?
Thank you very much, Tara. I will now explain whether L'Oréal might incur in civil liability for the child labour that's been identified in its jasmine supply chain. So the regime that L'Oréal is currently under is found in Article 225 and 102.4 of the French Commercial Code. It states here that companies with more than 5,000 employees in France, which L'Oréal is, must draw up and effectively implement a vigilance plan to prevent serious violation of human rights, health and safety. This obligation is something that extends beyond the company itself to its subsidiaries and subcontractors. L'Oréal therefore had a clear legal duty to monitor and prevent child labour across its jasmine supply chain, even beyond France. If that duty is not properly fulfilled, then Articles 1240 comes in and allows any person with a legitimate interest to raise a civil action for fault and seek compensation for the harm that could have been prevented by proper vigilance. 3 elements here then have to be satisfied, and I believe that all 3 can be satisfied. So firstly, fault. Child labour in Egyptian jasmine farms was a foreseeable risk. This is because previous media reports, including the BBC investigation, had identified children in the region as engaging in this practice, in harvesting harvesting jasmine. Therefore, L'Oréal's failure to specifically identify and prioritise this risk puts it at fault. Secondly, damage. The children suffered physical harm, loss of education, exploitation. These are all legally recognised forms of harm under French civil law. And thirdly, this is possibly the hardest to prove, causation. A link has to be made between L'Oréal's insufficient vigilance and the harm it suffered. I argue that as a major buyer at the top of the supply chain, L'Oréal had both the influence and the influence to determine pricing and sourcing conditions. Its failure to carry out adequate due diligence allowed unsafe and illegal practices to continue, which possibly could have been prevented otherwise. As a result, we can see here that it would be possible for victims or NGOs to bring a claim before the Tribunal Judiciaire of Paris to seek compensation for the children affected. I hope that everything was clear, and back to you.
Thank you, Rita. Now in studio, we're going to be joined by Pietro Leggeri, a criminal law specialist, who will present the potential criminal dimensions connected to decisions made at the headquarter levels. Pietro, welcome to the studio.
Thank you for having me, Tara.
So, Pietro, tell us, what can French criminal law actually do about this case?
Yes, I will try to explain the potential criminal exposure of L'Oréal under French criminal law, both the possibilities and the legal obstacles. Now, the first thing we need to do is establish jurisdiction of French criminal law. And under Article 113.2 of the Code Penal, France has jurisdiction when one constitutive element of an offense occurs in French territory. If L'Oréal executives in Clichy made decisions that constitute a criminal offense tied to exploitation abroad, then that jurisdiction anchor exists. Every pricing directive, every sourcing decision was made in France. The second thing we need to do is establish corporate liability. Under Article 121.2 of the Code Penal, corporations are criminally liable for offenses committed on their behalf by the organs or their representatives. The question here is not whether L'Oréal employees physically abuse child labor, but whether their decisions in France enable, tolerated, or incentivize practices abroad that fall within the scope of French criminal law.
So what offenses might apply?
So for L'Oréal to be considered an accomplice to an offense, Article 113.5 requires a foreign conviction first. So without Egyptian criminal proceedings against farmers or intermediaries, there is nothing we can do. Another option would be Article 125.4.1 of the Code Penal, which criminalizes human trafficking and exploitation, including benefiting from forced labor, degrading working conditions, and exploitation of minors, all of which resonate with the Jasmine findings. French criminal law captures corporate liability when the company, through its organs and decisions, knowingly benefits from or contributes to a system of exploitation. Now, if prosecutors establish that L'Oréal sustains pressure for extremely low prices, made lawful production economically unrealistic, and that executives were aware of the high-risk nature of Egyptian jasmine, then this supports criminal prosecution. But there is more. Article 121.3 of the Code Penal recognizes criminal liability also for involuntary injury, where harm results from negligence, imprudence, or breach of duty of care. When executives set pricing policies, making safety compliance impossible, receive repeated warnings about dangerous conditions yet fail to act, this constitutes a fault or an omission, a serious and identifiable breach of duty. If those omissions cause foreseeable injuries to workers, corporate criminal liability follows under Article 121.3 and 121.2. Tara, it all comes down to whether L'Oréal's organization made exploitation and injury a structural cost of a profitable business.
Very insightful. Thank you, Pietro. And finally, we will be joined by a corporate judge, Gordon Lee, who will offer a structured overview of how these issues could be addressed from the court perspective. Gordon, welcome to the studio.
Thank you for having me, Tara.
Thank you. So, if a suit was to be filed, how would you adjudicate?
Well, if I had to deliver a judgment on these facts, my conclusion would be very nuanced and fact-based and fact-dependent. Let me spell it out in legal terms, what kind of situations would lead to which outcomes, both civil and criminal. On the civil side, my primary tools are Article 1833 of Code Civil and Article 22535 of Code de Commerce and Article 225251 of Code de Commerce, Article 225124 and 225125 of Code de Commerce. So, let's look at the first scenario where the weak vigilance and the weak oversight. Suppose the vigilance plan is essentially boilerplate. The risk mapping mentions agriculture and raw materials in very general terms, but never really isolates Egyptian jasmine as a top-tier human rights risk. And assessment procedures are light, mostly questionnaires and announced audits, and preventative measures boil down to supplier code of conduct and some training sessions. After some serious media and NGO reports, the plan, the mapping, and the measures are barely revised. In that configuration, a targeted action of duty of vigilance under Article 225124 and 225125, brought by any claimant when to an entre-IG, has a strong chance of success. I'll likely find that the plan is substantively insufficient and order L'Oréal to revise and strengthen it, following the logic of the La Poste decisions. If, In addition, the board's minutes show almost no discussion of the specific risk over several years. Despite repeated external alerts, that the plaintiff can credibly argue a faute de surveillance under Article 225-251, read together with the judgment devoir de contrôle et de surveillance. And in that more aggravated scenario, some directors could realistically face civil liability.
Okay, but what about the criminal?
For liability, Article 121 allows the prosecution of a legal person, but Article 121-3 requires at least a faute d'imprudence, or in serious cases of faute caractérisée, breaching an obligation de prudence de sécurité prévue par la loi, and exposing identifiable victims to a particular gravity. The duty of vigilance can help define what diligence normal should look like, but we still need to clearly characterize offense, a territorial hook, and a robust causal chain between decisions taken in France and harms that provide particular children in the fields. And on the facts here, analyzing the penal threshold is not realistically crossed. The criminal liability of L'Oréal and its leaders remains largely theoretical. So, my overall judicial conclusion is this. First, the duty of vigilance action has a real chance of success where vigilance plans is generic and poorly implemented. And personal civil liability of directors under Article 225-251 is possible only in situations of clear, prolonged passivity documented in the board's own record. And for number 3, lastly, in criminal liability under Articles 113-2, -5, 121-2, and -3 on present facts is unlikely, frankly. It would require much stronger jurisdictional and evidentiary foundations. My role as a corporate law judge is to precisely draw that line, to distinguish what's morally shocking from what is legally provable, and to anchor any condemnation only in the duties that of the Code Civil and the Code Commerce and the Code Penal actually impose.
Thank you, Gordon, and thank you everyone for joining us on Corporate Law and Governance.